Hello everyone, this is Crypto BitLaw back with your blockchain legal brief, and today we're going to discuss a new development in the SEC versus Ripple Labs case, wherein the SEC scored a minor victory that could grant them some leverage against Ripple in the case going forward. But before we dive in, if you enjoy this content, please hit that like button and subscribe to our channel. We'd really appreciate that. And with that said, let's jump right on in. Okay, so we'll start here with the docket. You can see this is the docket in the case, Securities and Exchange Commission versus Ripple Labs Incorporated. And if we scroll down to the most recent events in this case, we could see that on March 23rd of 2022, there was an order granting a motion for an extension of time, and the SEC's request was granted. The SEC shall inform the court of its new position on whether any additional discovery is required within a week of the filing of the individual defendants' answers. So let's do a little deeper dive to see what this means and kind of parse all this out and what effect this could have on the case overall. Okay, so this Cointelegraph article does a somewhat decent job of explaining the implications of these developments in this case and what it all means. It states that the SEC scores a minor victory in legal dispute with Ripple Labs. So continuing on, they say the United States Securities and Exchange Commission, or the SEC, has been granted an extension to submit a discovery schedule relating to Individual Defendants CEO of Ripple Labs, Brad Garlinghouse, and co-founder Chris Larson as part of the case against Ripple Labs. The bitter legal dispute has been going on since late December 2020, after the SEC alleged that Ripple Labs generated $1.3 billion from an unregistered security offering via Ripple's XRP. The firm denies that XRP is a security and is instead a method for international payments, and has argued that SEC failed to give Ripple fair notice that the token was a security. While the ruling in favor of the SEC in this instance marks a small win, some onlookers have suggested that the enforcement body is dragging its heels and slowing the case down to frustrate Ripple Labs. Kind of like a battle of attrition. You've got the infinite resources of the government versus, I guess, a fairly substantial pool of resources with Ripple Labs. I mean, they do have billions of dollars at their disposal, but still, I mean, anytime you're involved in these battles of attrition, they can be hard fought. But continuing on, the latest development was highlighted by defense lawyer and former U.S. federal prosecutor James Phelan, who cited a text-only order from the court earlier today. Quote, the SEC shall inform the court of its position on whether any additional discovery is required within a week of the filing of the individual defendants, the order read. As part of the delayed schedule, the defendants now have until April 8th to submit an answer to the SEC's complaints, while the SEC's decision on additional discovery is due the following week on April 15th, and the joint proposed scheduling order is also due on April 22nd. However, the dates are not set in stone and could change depending on how fast Ripple Labs moves, with Phelan noting that, quote, the filing of the individual defendant's answer is the triggering event. When the answer is filed, even if before April 8th, the date the answer is filed starts the 2-week clock running for the filing of the SEC position on discovery and the joint proposed scheduling order. The XRP community reaction to the post was mixed, with some expressing anger at the SEC as just, quote, just trying to gain time in a case already lost, while others, such as Twitter user Cole the Mailman, suggested that the delays could be good for XRP in the long run. Quote, this is a good thing. The SEC will have no excuse as to timelines and more delays after a schedule's been confirmed. Also, they'll not be able to say that they were rushed when and if it comes down to summary judgment, they said. Personally, I would dismiss what these two people said, Cole the Mailman and this other guy, you know, with their frustration that they're dragging heels in a case already lost and no excuse for timelines. I mean, this is just kind of armchair quarterbacking or lawyering with people that don't really know the implications of everything that's going on. You know, it's kind of, okay, what law school did you go to, Cole the Mailman, that gives you a basis, a foundation with which to make that sort of an assertion? All right. We'll try to analyze the different facts and then apply them to the laws and see if we can actually get some sort of intelligent, insightful legal analysis here. There are a few main points of note. The defendant's answer, so the individual defendants, Garlinghouse and the other guy, the CEOs, their answer to the SEC's complaint against them is due on the 8th presently. And the SEC's decision on additional discovery is due on the 15th, April 15th. So after the defendant's answer is due, right? And so because they have, the SEC has a deadline for a decision on additional discovery after the defendant's answer is filed, that gives the SEC the opportunity and the ability to tailor their decision on additional discovery based on what they discover in the answer that's filed by those defendants. So based on whatever the defendants put into their individual answer, they can tailor their decision on that discovery request to the information contained in those defendants' answers, right? So you see how that could kind of tip the balance of power and leverage, although minutely, into the SEC's hands, right? In terms of a macro overview of this entire situation, what I really believe is happening here is that the SEC is trying to delay, right, until I believe Congress, either one of two things happens. Congress potentially regulates these issues and provides clear and concise definitions on what are considered securities. And if that happens, then that will essentially moot out this case. It's possible that that could moot out this case. So they're trying to drag their heels until Congress actually regulates this issue and codifies a series of laws and definitions that really clears up a lot of the ambiguity here. And that would probably be the SEC's best case scenario, and maybe even good for Ripple, because it could mean that based on whatever Congress defines as a security in terms of these digital assets, that maybe XRP isn't considered a security based under that hypothetical definition. And it would be good for the judiciary because, like I've said before, the judiciary doesn't like to do what's known as legislate from the bench, where you rule on an ambiguous issue, something that hasn't really been clarified by law, so you're interpreting law that is essentially, by precedent, almost creates a new set of law. So courts are really hesitant to do that. Alternatively, I think the SEC, in the event that they start seeing the tides turn against them and leverage starts getting out of their hands and weighing in favor of XRP and Ripple Labs, they would, I would foresee they would try to either withdraw or moot out their own case rather than getting any sort of adverse precedent or adverse judgment against themselves. That is the SEC. And this would be analogous to what recently happened in the Jarrett versus IRS case. And if, for those of you that are unfamiliar, that is the IRS proof of stake staking rewards case that has to deal with a couple that gained Tezos tokens by staking. And so they were rewarded with Tezos tokens through engaging in the proof of stake validation system. And then the IRS taxed them on those rewards as ordinary income. And so they sued the IRS, arguing that it wasn't taxable income. And then the IRS just ended up giving them a refund and then going to the court and saying, hey, we refunded their money, case over. And the Jarretts, the plaintiffs in that case, said, oh, not so fast. We want some sort of regulatory clarity. And so that's still up in the open as to what's going to happen in that case. But here, as we've said before, there were those two main ultimate resolutions that I believe would happen. Either the SEC delaying until Congress regulates this issue, or the SEC withdrawing in the event of either having adverse leverage against them or foreseeing a potential loss in their column. I don't think that they're going to let that happen. I don't think that they're going to let bad law be created against their agency and their positions. So with that said, I think we can turn to another recent development in this case. It's also a minor development. As we can see here in the docket, entry 454 on March 23rd, there was a letter addressed to the magistrate judge from the SEC dated March 23rd regarding leave to redact notes. Okay, and so turning over here, we could see a copy of the letter. And what the SEC is asking the magistrate to do is, we'll read it right here. The Securities and Exchange Commission, the SEC, respectfully requests leave to redact portions of the handwritten notes taken by the SEC staff who attended certain meetings between the SEC and third parties because these portions are protected by the deliberative process privilege, DPP. The handwritten portions in question expressly reflect either 1, the author's thoughts regarding the subject matters discussed during the meeting, or 2, deliberations among SEC staff during meetings. And so what we have here is it's another discovery dispute. The SEC, they essentially want to redact certain portions of handwritten notes that could weigh against them in terms of this issue of whether or not the SEC either thought Ripple was a security or intended on giving Ripple fair notice, the two main issues in the case. So they're trying to redact these portions of those notes. How this will play out, who knows? That's going to be up to the court, but just giving you the information as we see it. So, with that said, I hope you enjoyed this content. If you did, please hit that like button and subscribe to our channel. We'd really appreciate that. And thanks again for watching, and we'll see you all in the next video.